came here and testified that the internal memo dated 23rd February was a forgery. She saw an affidavit that was presented to this House. Honorable Senators, the said memo bears no name, and there can be no clearer indication than this that it is indeed a forgery. In the opening remarks by the Governor's Council, this House was told that the Assembly is lying, and in fact the words used were that the Assembly is made of pathological liars who have believed their own lies. In view of this forged memo, I therefore ask this Honorable House, and I invite the Senators to ask, who is lying? The same Governor who accuses this Assembly, the County Assembly, of lying, is caught forging that internal memo. A ruling was made this morning that she should deliver the original memo. She has failed to do so. The Governor, in the same pattern of lies, stands here and tells you that she has 23 MCAs supporting her. The impeachment motion, a cursory look will tell you it was signed by 49 MCAs. And simple math tells you that 49 plus 23 is 72. Yet, shockingly, the County Assembly of Meru has only 69 MCAs. So it cannot be true that the Governor has 23 MCAs supporting her. The Supreme Court in the Sonko case was categorical that there is no obligation in impeachment proceedings to prove each and every charge, and this means that even one charge substantiated should suffice. In that case, Honorable Senators, guidance was offered that impeachment proceedings are quasi-judicial in nature and are not in the nature of criminal proceedings. They don't necessarily require that criminal culpability should be proven to succeed. All that is required is that these allegations be substantiated. This word substantiate, what does it mean? It simply means to provide evidence. It does not necessarily mean to prove beyond reasonable doubt. It means that there must be substance in those allegations, that they have been proven to have substance. Honorable Senators, as I conclude, the evidence presented before this House cannot be trivialized to statistical count as an attempt was made in cross-examination of the mover. The gender card cannot be used to escape accountability. It is not a carte blanche or a shield to commit impunity. It is not about being female or male. It is about violations of the law and the Constitution. Honorable Senators, finally, in paragraph 7 of the Governor's response, that is volume 1 of the Governor's document, she seems to suggest that the county government of Meru should be dissolved. I call on this House to reflect on the words of the Bible in the book of Matthew, chapter 18, verses 8 to 9, and to paraphrase the words of Jesus Christ as he was teaching the people then: if your hand or your foot makes you sin, cut it off and throw it away. For it is better to enter the kingdom of heaven maimed or lame than to be thrown to everlasting fire with both feet and hands. There is no cause for dissolution of Meru County. The problem is the governor, and Meru can be saved by removing the governor from office, as the Constitution empowers the County Assembly and this Honorable House to do. Thank you, Mr. Speaker, sir, Honorable Senators, and I pray that you will find that the charges against the governor have been substantiated, and I pray that in keeping with the motto of this Honorable House, for the welfare of society and the just government of the people, including the people of Meru, that you will do the right thing and send Governor Kawira Mwangaza home. Thank you. I invite my senior, Mr. Ndegwa, to conclude our closing.
Thank you very kindly. I must begin by conveying the apology on the part of the County Assembly for having to engage this distinguished assembly in all these processes. It is not out of the own making of the County Assembly. It is a call of necessity. Necessity has dictated that we must come before you as and when time and situations and circumstances arise. A situation has arisen where we have to come before you, honorable members of the Senate, to ask you to do your noble thing of exercising oversight over the county government of Meru. I have time and again put it on record that the County Assembly of Meru and the people of Kenya have a lot of confidence in the manner in which this House conducts its business. It's on that basis, therefore, that we have been able to appear before you severally, seeking and pleading for only one thing, that justice be done in the county government of Meru. And what justice are we looking for, honorable members? We are looking for justice of that particular person who is not able to access services, courtesy of bad governance. What justice are we looking for? We are looking for justice of that child we saw who was born on a karai, that child who cannot speak, that child whose fate is not even determined. And when the governor is put to task, says, I have just been made aware. How would you take that governor to be a responsible person? How would you take that person to be a person who is capable of enhancing good governance, delivery of services? How is it that she was not aware that that hospital is not functional? How is it that she is not aware that that hospital or dispensary has a functional maternity wing? She takes no bother to confirm why the hospital was not functional as at then. Even having been made aware as at yesterday, she still says, I am not aware. Is that the governor who is capable of running the county? Is it really the mistake of the part of the county assembly? Or is it the county assembly being invited by the misconduct and the misdeeds of the governor? Can the county assembly of Meru County sit pretty and watch things go south? Isn't it their responsibility to exercise oversight over the performance of the county government? Are they wrong when they invite the Senate to help and assist and facilitate the operationalization of the oversight function? That is all what we are asking for. That is all what we are asking for. If we were in the UK setup, this house qualifies to be the House of Lords. It's a House of Lords because it's capable of determining where the truth is and where the lie is. Evidence has been led from the county assembly. Grounds were approved by the mover of the impeachment that it is true the governor has transgressed and violated the constitution. When she was put to task to explain the circumstances that led to the revocation of that CEO, she simply said, it wasn't me. And how can it be that the governor can be allowed to get away with a forgery? Isn't it a criminal case in the first instance? And who has a burden of proof? The person who claims that the signature was forged appeared before the Senate. Her evidence was put through test by cross-examination, and clarification and verification was sought by the members of the Senate. Who then is lying? Is it Linda Kiome, or is it the governor? Can the governor be trusted? Put to task and granted an opportunity to bring even the original advisory, she simply said it was seated somewhere in Meru. Unfortunately, she mistook where the place of the trial. The place of the trial is not in Meru, it's before this Senate. Is that a conduct that is consistent with innocence? If she was innocent, if it was not forgery, why was it so difficult for her just to bring that one letter? Why could resources not be committed to make sure that as and when she was made aware that that is an issue, that a letter could not be procured 180 kilometers away from the place of the trial? What is she concealing? What is she hiding? Is she hiding scrutiny? Is that conduct again consistent with an innocent man or innocent woman? I urge you, honorable senators, to find it in our favor that we have proved that particular ground. That the letter that was meant, that the advisory that was meant to rebut our evidence in respect to ground one is a document that is a forgery. In the case of Philomena Mwilu, the Deputy Chief Justice of the Republic of Kenya, it was held that evidence that is tainted with illegality, it cannot be admitted. The admissibility of that evidence is in question. And having read the case of Wambora in the Civil Appeal number 21 of 2014, the Court of Appeal suggests that this is a quasi-judicial process. And it being a quasi-judicial process, the rules of evidence plays a fundamental role in the manner in which the admissibility of document is concerned. I sought leave of this House to have the document placed on record. They took no initiative. Why? Because they wanted to conceal the lie. They wanted to conceal the offense of perjury. They could not withstand the embarrassment that a signature was lifted. It matters not whether the governor is an IT guru. It matters not whether she is techno-savvy. It matters that a document was brought before you that is as a result of a forgery. We seek that you find it in our favor, that that particular ground was not defended, it was not controverted, and that the ground suffices to meet the test laid down under Article 81 as read together with Section 33 of the County Government Act. And then what is the threshold in terms of that particular charge? The threshold is that of it lies between balance of probability and below beyond reasonable doubt. That is what the case of Governor Wambora stated, that we are not supposed to prove. The burden of proof is not beyond reasonable doubt. It's not beyond reasonable doubt because this is not a criminal trial, and that distinguishes the case from the case that was quoted by Senator Kajwang, that this is not a criminal trial to seek the county assembly to prove the case beyond reasonable doubt to the extent of seeking the intervention of a forensic document examiner. It's on balance of probability. Whom should we believe? Who should we believe? Is it the person who has committed serious transgressions? Is it the person who is not in touch with the county? Is it the person who is in war with all the leaders in the entire county? Is it the person who is not even in good terms with his senator? Whom should we believe? Should we not believe leader? What personal vendetta would leader be having? She is not vying for a seat of governor. It matters not that whether she was a running mate to the previous candidate or not. But it matters that an offense was committed. We urge you, honorable senators, to find that in revoking the appointment of CPA Virginia Kawira, Governor Kawira violated the Constitution. She violated Article 10 of the Constitution on the question of the rule of law. She violated Article 27 on the equality before the law and the equal benefits of the law, that Virginia was not subjected to equal protection and equal benefit of the law under Article 27. She equally violated Article 70, Article 50, that she was not given a fair trial or a fair opportunity to defend her case. When put to task, she attempts to become a linguistic, to purport to differentiate between removal and revocation. When called to task to read the provisions of Section 58 and Section 59 of the County Government Act, honorable senators, she simply could not distinguish. At the end of the day, whether a revocation or a dismissal, it never followed the due process. The County Assembly was never involved. It violated that particular provision. And for that reason, Governor Kawira must take responsibility. Taking responsibility is not an act of cowardice. It's not an act of weakness. It's an act of saying, yes, I was wrong. It's an act of admitting when somebody is wrong. And that is what Article 10 speaks about, the question of accountability. And that is what Article 73, which Governor Kawira has violated, speaks about. Article 73, honorable senators, speaks about a person who holds the office of a governor or any other office in the Republic of Kenya, breathing confidence in that particular office. When Governor Kawira lies blatantly, openly to the whole world that she was able to procure an advisory opinion, who can believe her? Is she breathing confidence in that particular office? Should she not be held to account? Is she not bringing that office to disrepute? Honorable senators, we submit that that particular charge has been sufficiently proved. On the question of the appointment of the chairpersons, again we prove that we have been able to dispose of our burden of not proving this allegation beyond reasonable doubt, but on balance of probability, that yes, Governor Kawira has crippled the operations of the Meru County by blatantly failing and ignoring and or neglecting to execute her functions as the chief executive of Meru County. That amounted to the violation of Section 4 of the Public Appointments Act, in that requires when the governor is bestowed with the responsibility of a duty to follow the provisions of the law, can she be acquitted? How many times is Governor Kawira going to commit transgressions and get away with it? How many times? When she gets away with the transgressions, where do we leave the people of Meru County? Do the people of Meru County equally deserve justice? Should there not be a balance between the people of Meru County? Where should the balance lie? How should the balance swing? In whose favor is the balance swinging? I suggest and propose and submit that the balance swings in favor of the people of Meru County. They deserve justice before this house. They are crying out for justice. They are looking upon you to dispense with justice. And there cannot be justice by sending Governor Kawira back to Meru. The only justice that can be served, I suggest, is telling her you have failed in your duties, you've neglected in your duties, you have violated the Constitution, you do not know what the Constitution dictates. Remember, she swore to defend this Constitution, but she is one of the greatest transgressor of the same document that she's seeking solace and reprieve from. Honorable senators, Governor Kawira has come before you with dirty hands. She deserves no favor. She deserves no kindness. She deserves no kindness before this particular house, before this Senate. She has come to you with dirty hands. She is not even remorseful that a toddler was born in a Karai when there is just an adjacent health facility. There will be no any other reason for sending Governor Kawira home. Please remember the fate of that particular child. Remember the fate of that particular mother who got embarrassed on that particular day. Remember the interpretation that was done, that men and women had to make sure that young children do not go near that naked woman to see her nakedness. How many embarrassments will this house be treated to? Isn't that something that we need all to take cognizance of? Was that video proving failure of service delivery? Who is responsible of delivering those services if it is not Governor Kawira, who has proved on oath that she has failed? Who else should we hold accountable? Who else should we hold accountable? Should she even be allowed to hide behind the cultural card? She has said and submitted that it's the culture of the Meru people to become and to look down upon women. I believe honorable senators who are present before this honorable house, including the senator of Meru, is a family man. There must be a woman in that particular house. If the senator is a misogynist, how does he live with his wife in his house? How does he live with his daughters in his house? If it is true the people of Meru are masculine, how do they multiply and perpetuate the Meru generation? That is a blatant lie. She shouldn't be allowed to hide behind issues that are not founded either in law or in fact. She must be told it's now time for you to go. She must be told we have given you 2 opportunities, you have failed to reform. She must be told the Senate has listened to you severally, but you have failed to conform. She cannot conform, she will not conform, she will not reform because she is not a reformist. She does not understand the story of a reformist. Or what she understands, as indicated in her submissions and evidence, is that the county government, the county assembly is telling the story of the single story. Which other single story have we told the Senate other than the single story of the violations of the Constitution? Which other single story have we told this House other than the story of the suffering of the people of Meru County? That is a single story. We have no other story. It's a single story of the suffering of the people of Meru County. They are craving upon you, honorable senators, to save them. They are craving upon you to save them from all these blatant violations. On the question of refusal to implement the recommendations by the county assembly, you might want to ask yourself, why the failure? It was not a coincidence. It is by design. Because it's the conduit between the governor, the chief of staff, and the county secretary. That web must be in existence for Governor Kawira to exist. That is why it was impossible for her to implement the report recommended by the county assembly. Those are her conduits. If you find any mismanagement, any embezzlement, any failure of good governance, look at that web. It must be maintained for Governor Kawira to continue transgressing the county. It must be maintained for Governor Kawira to continue perpetuating the suffering of people of Meru. Why is it so difficult for her to implement that report? Why is it difficult for her to see that there was necessity for her to implement that report as recommended by an equal arm of her government? The answer is one. She needs that network for her to perpetuate illegalities that she's perpetuating currently in Meru County. When put to task whether the reports and why they were not implemented, she simply said they were not sent to me. Evidence was led that yes, they were submitted to her, they were received in her office, and she blatantly refused to act to it. Why? I think and submit that she does not understand the weight behind accountability. She does not understand the weight behind transparency. She does not understand the reason why there is a rule of law in this country. Count 2 on misconduct. Yes, she acknowledged that she made those particular statements. She said, yes, she made those statements about the 86 million. She acknowledged misleading the people She acknowledged that there was not only one account and that whatever she was saying was falsehood. If a leader cannot be held account for the statement that they make, then where is this country going? We must tell the current generation and the future generation that it is important to speak the truth, that it is important to stick to the way of the truth. That is what is right, that is what is just. Did Governor Kawira maintain the path of truth? Did she stick to the path of truth? Did she do what is right in the circumstances? We submit that she willingly veered away from the path of truth. The evidence of the window, and may he rest in peace, was never tested. None of them cross-examined that lady. Her evidence went uncontroverted. Is it usual for a defense counsel not to test the veracity of the evidence of a witness who is putting up a case, and a serious case such as this one? It is not usual. They only knew that they have nothing to cross-examine that lady on, and that whatever she said is therefore truth. And as such, we submit that Article 10 again was proved which speaks to values of and principles of governance. Among them, the value of good governance, the value of integrity, the value of accountability, the value of transparency. How can a person lead a county if she has a deficit of integrity, if she has a deficit of accountability, if she has a deficit of transparency, if she cannot respect the rule of law? How can she lead the county? The county performance is premised on the laws. It's premised on the rule of law. If she does not respect that rule of law, is she then worth her salt? Look at Article 73 of the Constitution. It's paramount when seeking to establish whether or not this allegation has been substantiated. It speaks about the authority assigned to a state officer. It speaks about public trust must be exercised in a manner that is consistent and demonstrate respect for the people. Does that video and the conduct that was exhibited before this assembly demonstrate respect for the people? Does it bring honor to the nation and the dignity of the office of the governor? Does it promote confidence, public confidence in the integrity of that office? We submit that the conduct exhibited by the governor, through the evidence of the witness that was not controverted, flies over the face of Article 73, and that does not breathe confidence. It does not demonstrate respect for the people. It does not indicate integrity. It does not bring honor to that office. If she cannot honor that office, why should she hold it? If she cannot honor that office, why should he keep it? If she cannot honor that office and she has no dignity for it, why should she keep it? Honorable Senators, I urge you to find it that provision has been proved and has been substantiated. On the question of paying Kiambi's Christus Manyara, it must be remembered that she has admitted on oath that this Kiambi Crispus is a person who works in the office of the county governor. She has admitted on oath that evidence has been laid that he is one of those people who are accused for the murder of and the slaying of a sniper. Put to task why he continued to earn his full salary while still in custody for 6 months. She simply said, "It wasn't me." When will Governor Kawira learn to be responsible? When will she ever learn to own up for a mistake that is so glaring such as this one? She takes no cognizance that money was spent unlawfully. She takes no cognizance of the provisions of Article 201 of the Constitution. Honorable Senators, Article 201 is paramount in the manner in which the resources of this nation are governed. Article 201 speaks about the principles of public finance, and it provides that there must be prudent use of public finances. Was this one way of prudent use of those resources? Why should a person who is in remand continue to earn a full salary? Why should actions not be taken for a person who perpetuates these violations? It speaks about openness and accountability, including financial integrity. Was that the best way of applying the meager resources? Honorable Senators, as I pen off, I urge you to fight it, that this act and conduct must be attributed to the governor. There is clear nexus that the governor knew that this person is in custody, having worked in his office. It then irresponsible of the governor not to know that a person attached to her office is not in office for 6 months. How responsible is that governor if the governor cannot learn that a person who is attached to her office is not present? How can she be allowed to get away with this? This is a governor who is incapable of running the affairs of Meru County. We ask you, Honorable Senators, and we humbly submit that you pave way for her to have another person manage the affairs. This is not about being a woman. Accountability is not being a woman. There's nothing to do with being a woman when you are called to order. We are all called to play allegiance to the Constitution. It's so easy to tell a lie, but so hard to maintain the same. Telling a lie is the easiest bit, but telling the truth and pretending that you are lying is so hard. Success and any other success requires that an individual must accept responsibility. Kawira Mwangaza must accept that the county is not functional. It is not functional courtesy of her misdeeds. Accepting that one has failed is not a sign of weakness. Accepting that one has failed is not a sign of weakness. It's rather a signal that is being directed towards that particular person to check her true north. As I sum up, accountability is when you accept responsibility for the consequences of your actions. Accountability is when you accept consequences for your actions. And consequences for the actions, as proved by the County Assembly, demands that Governor Kawira must go. As I sum up, and I want to repeat what I earlier submitted, that for there to be proper running of the county government of Meru, Kawira Mwangaza must go. For there to be services, proper delivery of services in the county government of Meru, Kawira Mwangaza must go. For the women of Meru County to access maternity services, Kawira Mwangaza must go. For the babies of Meru to be saved from the embarrassment of being born in Akarai, Kawira Mwangaza must go. For proper running of the Meru County, Kawira Mwangaza must go. It's only proper for her to leave, to pack and go. She has demonstrated incompetence. She has demonstrated her inability and incapacity to deliver services to the people of Meru. We urge you, Honorable Senators, to fight it in our favor and send Governor Kawira home. Let her not hide behind other leaders. Let her not say that political leaders have instigated this motion. She has not brought as a witness any person, including any affidavit swearing that the senator of Meru County is behind this impeachment. Let her not play the victimization card. Let her not hide behind victimization. Let her take responsibility for our actions. Na kila mtu atauchukua mzigo wake mwenyewe.
Council, this is a house it rules.
I submit.
Yeah. Council for Governor, the floor is yours.
May I proceed, Mr. Speaker, sir?
Absolutely.
Thank you so much, Mr. Speaker, sir, and thank you so much, distinguished senators. For the record, my name is Ongoya. I'll be making the governor's closing submissions. Distinguished senators, courtesy demands that I open this process by thanking this House for the opportunity given to us as council and the opportunity given to the governor to be heard as we have been heard. The challenges associated with the time notwithstanding, we are satisfied that we have had a fair day in this honorable House. Distinguished senators, the governor invites this House to be guided by certain enduring principles that she will draw the attention of this House to. The governor invites this House to be guided by the guidance that was applied by the famous philosopher Socrates to all persons sitting in the position of judges, which you now do. 4 things belong to a judge: to listen courteously, to answer wisely, to consider soberly, and to decide impartially. There is a biblical injunction that also addresses itself to the attributes of judges. I think there's advice that was given by a man called Jethro to a man called Moses in the book of Exodus, when Jethro thought that Moses was spending significant amounts of time deciding cases. He advised him to appoint judges to help him decide disputes between the children of Israel. He gave the following attributes: able men, such as fear God, men of truth, hating covetousness. The governor holds this Senate in the highest possible regard and attributes these attributes that have survived the age of time to this Senate. Allow me to deal with what I consider to be some side issues that have arisen in the course of this trial and in the course of the Assembly's final submissions. Distinguished senators, an issue emerged as to whether ISPAC member number 10955, Kirimi Ibrahim Mutwiri, is an active member of ISPAC in good standing. Fortunately for us, like many other professional bodies, the data of many of us professionals is now available in the public databases of the respective professional association. Any senator who cares to search member number 10955 on the member search engine of ispac.com will get a chance to satisfy themselves as to the active status and good standing status of that member. I repeat, member number 10955. Each senator is at liberty to search on the website ispac.com/search-member to establish for themselves the standing of that member. I say that with great humility because it's important that we address ourselves to the substantive issues that have kept us here and that keep us here up to now. It is not for lack of other business. The governor believes that distinguished senators are sitting in this house after 9 p.m. to resolve this dispute. the governor believes that the issue before the Senate is so significant that it should never turn on a matter of side issues. And one senator's search member number 10955 in the icepack.com search engine and establish the active and good standing status of that senator, of that accountant, my apologies. They will then form their own opinion as to who is standing on the platform of truth and who is standing on the platform of lack of truth in the conduct of these proceedings. Mr. Speaker, sir, I'll beseech the timekeepers to remind me at intervals of perhaps 15 minutes because I like managing my time as I get along. It's just my humble plea. Mr. Speaker, sir, distinguished senators, impeachment processes, as I have said before, are processes governed by law and legal principles. It is now settled by no lesser authority than the Supreme Court of the Republic of Kenya that public participation is an important pillar of the impeachment process. It therefore means that if an impeachment process is undertaken on a foundation of lack of proper public participation, then that particular impeachment process cannot stand the test of scrutiny. I want to take these senators through the public participation report in volume number 5 of the County Assembly's documents so that these senators in themselves can ascertain whether that principle was satisfied. If the senators can access volume number 5, the largest possible volume of the County Assembly's documents, I'll beseech them to look at page number 35 of that document. Page number 35 of volume 5. It's the biggest volume in the County Assembly document. And if you look at page number 35, there is a photograph on that page which is supposed to be a photograph of the members of the public attending a public participation function at Abogeta West Ward. I then, distinguished senators who have seen that photo, beseech them to look at page number 30 of the same volume. Page number 30 of that volume, which is supposed to be now the public participation event at Abogeta East Ward. On the face of it, the same people in the same sitting arrangement, taking the same posture at page number 30 at Abogeta East Ward are the same people in the same sitting arrangement taking the same posture that you'll discover at page number 35. I leave it to your able judgment about what that says of the integrity of this public participation process. But that's not enough. I'll beseech distinguished senators to turn to page number 331 of that same document. 331 of that same document. May I urge that we start at page 330 for proper context. At page 330 is a title of minutes showing that this should be a public participation event at Akirangondu Ward, in Akirangondu Ward at Machungulu Social Hall. I'll beseech distinguished senators look at minute number 3, which runs from page number 331. And I wanted to look at the entire of that minute from where it starts all the way overleaf to page 332. To make my point, I would ask the senators, while keeping their finger on that minute, to turn to page number 373 of the same bundle. While keeping a finger on this page 331, to turn to page 373 of that bundle, they will see that these are supposed to be minutes of a public participation function in Mbeu Ward at a place called Kimiri MCK. These are supposed to be events done on the same day at the same time. You realize that minute number 3 of those minutes starts at page 374 and turns overleaf to page number 375. This minute takers somehow meticulously used the same words word for word across 1.5 pages of minute taking of an objectively taken set of minutes. Distinguished senators, while at it, I want you to turn to page 390 of that same bundle. When you turn to page number 390, you'll come across a public participation event that apparently took place in Igembe East Ward at a place called Karaune MCK. And just for comparison, I will then urge you to turn to page number 393. 393, which is supposed to be a public participation event in Adiru Rugine Ward. I try to understand how to pronounce this name in Meru language, a lot of difficulty. Adiru Rugine Ward at a place called Akune MCK. Putting your finger on those 2 minutes, I want you to look at minute number 3 of each of those 2 minutes. The one at page 390 starts from page 390 through page 391 all the way to page 392. And the one starting at page 393, minute 3 starts at page 393 through page 394 all the way to page 395. And you'll discover those minutes use the same words in the same order, the same sentences in the same order, word for word, across 3 pages of minutes. I leave it to able judgments, applying this Socratic standard that I have just prescribed for this sentence. Courteously, you answer wisely, you consider soberly, and you decide impartially, distinguished senators. Would you say that this is a public participation process that passed the requisite test of integrity? I just want to demonstrate one thing which can be done without taking too much time, which is page 332 of that document. At page 332 of that document, which is part of the minutes of a public participation event taking place at in Akirangondu Ward at Machungulu Social Hall, at minute number 4. At minute number 4, you'll come. Sorry, my apologies. I want us to go to page, my apologies. I misled you when I referred to 332. I want us to refer to 370. Let me see where this brings out the point, then I can conclude just so that we don't waste a lot of time. Let me look at 373. If it doesn't, I'll just go to the next minute, then we clear that in a short while. Yes. Thank you so much. That is the one. I wanted to look at page 332, minute number 4 at Akirangondu ward. The minute taker says as follows: members of the public, upon equal and fair representation from across the locations in the ward, ended the meeting at 1 p.m. Full stop. A member of staff from the county assembly gave closing remarks and thanked the members of the public for exercising their constitutional mandate and conducting their exercise peacefully and inclusively. When you go to page number 375, which are minutes of a completely different ward, you also see minute number 4 in Mbeu ward, where members of the public, upon equal and fair representation from across the locations in the ward, ended the meeting at 1 p.m. A member of staff from the county assembly gave the closing remarks and thanked members of the public for exercising their constitutional mandate and conducting the exercise peacefully and inclusively. The same minute, the same words in the same order. I spoke here about some things being too fantastic to be true. Distinguished senators, these are the sort of things I was referring to. Normal human fallibilities militates against this kind of coincidences. I'll briefly make that point by looking at page 392. At page 392, of the minutes from Igembe Eastward. Page 392, after Roman 11 up there, there is an entry: a lady who spoke and was not in support of the impeachment motion said that since the governor was a woman, the MCS were planning to impeach out and needs to give her time to work and complete her term. It follows, another one said that she doesn't support the impeachment motion because the governor is the only senior most politician from Meru County. I want us to turn to page 395, which is part of the minutes from Adiru Rujine ward. Just after Roman number 11, a lady who spoke and was not in support of the impeachment motion said that since the governor was a woman, the MCS were planning to impeach her out and needs to give her time to work and complete her term. It follows, another one said that she doesn't support the impeachment motion because residents of Meru County are tired with these unending fights between the governor and the MCS. Distinguished senators, I leave it to your able judgment as able men, such as fear God, of truth, hating covetousness, using this standard of Jethro as he advises Moses, to determine for yourself the quality of public participation that underwrites this motion. We are looking at a document that is 1,344 pages. Time cannot allow us to continue with this kind of analysis, but the point has been made. Allow me to move to the next point. I want to deal with the various allegations that have been made against the governor in this impeachment motion. If you look at the impeachment motion at count number 1, the governor is accused of gross violation of the Constitution and other laws, and a general allegation of violations of laws is made there. The burden for us is to establish whether the ground in support of that allegation has been made. I would start by dealing with ground 4 for good order. I will deal with the other grounds as I carry on with these submissions. The governor is accused of dismissing Dr. Ntoiti, Paul Mwaki, Kenneth Kimathi Mbae, and Joseph Kithure in usurpation of the powers of appointing authorities. The mover of the motion was taken through this ground as against what was count 4, paragraph 16 of the motion that was before this House in November last year, my apologies, in November last year. She confirmed that there has been no new action on the part of the county government in respect of these officials. She confirmed that what she was complaining about here is the same action that informed the previous allegation in the previous impeachment motion. While at it, and so that I don't revisit this question, I'll also deal with count number 3, paragraph 3 of the present motion, where the governor is accused of employing a bloated workforce of at least 111 personal staff in her office. The mover of this motion came here and she conceded that this was the same allegation in count number 4, paragraph G of the motion that this Senate dealt with in November last year. The question I want this Senate to grapple with is this, and this is a question of principle. Is it permissible for this Senate to be called upon to re-debate the same fact over which it debated and acquitted the governor? Is it permissible in law? Is it permissible in good sense to re-debate and make a decision on it? Are these grounds you are going to vote for, or are these grounds in your private discussion and deliberation are going to move that must be struck out first before you consider the residue of the motion? That's something that I invite this Senate to grapple with so that it guides future processes of this nature. I'm making out an argument that the governor invites this Senate to take a position on allegations that have been debated here in previous impeachment motions and in respect of which the governor has been cleared of the same. May I draw the attention of this Senate to the fact that the move of this motion confirmed that in respect of the claim of employment of a bloated workforce, the same list of employees in the same order that was presented here in November last year is the same list of employees in the same order that she has presented here today, and sought that this Senate reviews its previous decision and enters a different decision from the one it entered last year. The second set of matters that I want to deal with is matters that are pending active litigation in court as we stand here today. What I describe as matters that are sub judice. Count number 1, paragraph 1 of the impeachment motion alleges that the governor illegally revoked the appointment of CPA Virginia Kawira Miriti as CEO of the Meru County Public Service Board. Distinguished senators, it is not in dispute that this matter is pending active litigation as Meru Employment and Labor Relations Court, case number E002 of 2024, Virginia Kawira Miriti versus the governor, Meru County. The governor invites this court to consider as a matter of principle what is its policy on matters sub judice. what is the policy of this Senate on matters that are pending active litigation before other competent institutions of dispute resolution. No problem. Evidence of the pendency of that case has, of course, been supplied in volume number 2 of the governor's documents at page number 14. Another matter that the governor wants you to apply the same mind on, that is matters that are actively pending in court, is what I referred to earlier as count number 1, paragraph 4, on the alleged illegal dismissal of Dr. Ntoiti, Paul Mwaki, Kenneth Mbae, Joseph Kithure Mberia. In addition to the fact that this is a matter that this Senate has already applied its own mind upon and made a decision on, it is not in dispute that this matter has been and continues to be in active litigation in our court. This matter went into court as Meru Employment and Labor Relations Petition number 1 of 2022 and is now pending an appeal. Evidence of the pendency of that appeal process is at volume number 7, at page number 71, volume 1B of the governor's documents. Again, distinguished senators, with tremendous humility, I invite this House to take this as a question of principle. What is the policy, the legal policy of this Senate on matters that are actively pending in our courts, such as ground number 1, paragraph 4, count number 1 of this impeachment motion? If you look at ground number 2, paragraph 6, and ground number 3, paragraph 11 of the impeachment motion, that motion, just for good order, is in the County Assembly's documents, volume 1. This is the matter relating to the alleged, or the case of murder of one Daniel Mudhiani, alias Sniper, and contributions towards his family, and the role, connection, or status of Kiambe Crispius Manyara, an accused person in that murder. The County Assembly, at volume number 2 of its documents, at page 429, has supplied this House with the charge sheet for that murder case. Distinguished senators, I beseech you to again make a principled decision in a matter such as this, where the County Assembly by its own documents admits that it's a matter pending active trial in our murder court, our high court. What is the policy of this Senate towards matters such as those? I submit that this is a matter of principle, because this should be able to guide future impeachments, so that we don't have to revisit these questions of principle. People can be guided by the decision of this Senate once and for all. Finally, the impeachment process itself in its entirety, I wish to refer you to volume number 2 of the governor's document at pages 28 to 32. At page 28, you can see Meru Constitutional Petition number E013 of 2024. The parties to that case are Honorable Kawira Mwangaza, petitioner, and the County Assembly of Meru, respondent. The two parties now appearing before you and represented by counsel, as has been the case. If we turn to page number 31 of the Governor's volume number 2, there is a ruling of court which says the upshot of the above is that the impeachment process is halted pending my ruling, and since this matter is of public interest, the ruling on the interested parties and the main petition will be delivered on 29th July 2024 via email to all parties. It is in the public domain that that ruling was not delivered on that day and is still pending delivery, and this order remains in force. As a matter of principle, I invite senators to reflect on this question, because the governor has been brought here by the county assembly claiming that it wants to strike a blow for the rule of law. And yet we are here debating this matter in the face of an order reading, and I quote, "The upshot of the above is that the impeachment process is halted." As a matter of principle, distinguished senators, what position do you want to take on this matter? You are the judges. You will make the decision one way or the other. I have done my part as legal representative to my client. I have made full and candid disclosure that we may be perpetuating a violation of the rule of law. We may be. I am not the decision maker. I leave the eventual decision to your able hands, distinguished senators. Is this the way we shall grow our institutions? If a court of competent jurisdiction can make an order such as this, the county assembly proceeds in violation of this order. The governor has told you on her part she has taken some action on this violation, and at page 35 onwards you will see a contempt of court application that she has filed. She has done her part. The court will deal with that. Shall we, sitting here in good conscience and our attention having been drawn to these facts, perpetuate this process which on the face of it the county government has undertaken in violation of a valid court order? It is not for the governor, it's not for her council to make that decision. Distinguished senators, the heavier task lies with you to make a decision one way or the other on these questions of principle, touching on those specific paragraphs of those specific counts that I have alluded to, and on this impeachment process as a whole, as I have drawn your attention to page 30 of volume number 2 of the governor's documents. Let me proceed by addressing you briefly on the Public Audit Act. Distinguished senators, I beseech you, as you make this decision this evening, to be guided by the provisions of Section 53 and Section 54 of the Public Audit Act. I say this in summary in response to the multiple audit questions that have arisen in the course of this hearing. Time will not permit me to point at specific audit queries. Having been present here, we know those audit questions. Section 53 of the Public Audit Act has a side note entitled Implementation of Reports. These are audit reports by an accounting officer. Implementation of reports by an accounting officer. Subsection 1 of Section 53 of the Public Audit Act provides, and I quote, The relevant accounting officer of a state organ or public entity shall within 3 months after Parliament has considered and made recommendations on the audit report. So first, there is an audit report. 2, there is parliamentary consideration of the audit report. Then 3, there are actions to be taken, which are take the relevant steps to implement the recommendations of Parliament on the report of the Auditor General, or give explanations in writing to Parliament on why the report has not been acted upon. The law itself actually anticipates failure to act on those reports with reason. Honorable Senators, there is a principle in law called the subsidiarity principle. The subsidiarity principle in law dictates that a dispute must be resolved at the lowest institution competent to resolve it. So, for example, as a litigation lawyer, if I have a case that can competently be handled by the High Court, but when I look at the law, it can also competently be handled by a lower court, a magistrate's court, I am obligated to file that case in the magistrate's court, which is the lowest court competent to hear that dispute. We now know that the County Assembly of Meru has not exercised its mandate by seizing these reports and making necessary recommendations or steps to be taken to implement the report. Instead, it has picked the reports and come to this house with those reports. I want to believe, speaking for myself, that that is overburdening this very busy house. I want to suggest to you, Senators, that if you set a precedent here in these proceedings, that a county assembly can do that, it means that if we get a year where there are 47 county governments with some issues, and you know better than I do, that virtually every year, every county government has some issues in the audit report, it is possible for county assemblies to bring here 47 impeachment motions. I suspect that that may break the functional machinery of this house. I think that you better take a position in this matter that reminds county assemblies that they also have a role to discharge. To sit, invite relevant officers of the executive, interrogate audit reports, resolve disputes that can resolve there first, then come here with only such residues of issues that the relevant officers have proved to be incorrigible. That is my humble submission, distinguished Senators. There is a cadre of claims before you where I submit respectfully that the County Assembly is in fact the author of the problem. Then it has brought the governor here. The alleged failure to appoint chairpersons of the Meru County Revenue Board, Meru Microfinance Corporation, Meru Youth Service Board, and Meru County Investment and Development Board. I invite you to look at the correspondences at pages 53, 54, 57, 58, 60, 61, 62, 65, 67, 84, and the document at pages 85 all the way to 163, and the document at page 135 of volume 1B of the governor's documents. I will not read them, but save just to summarize that these are the multiple correspondence between the office of governor and the office of the clerk of the county assembly. There is no doubt, distinguished senators, that the governor nominated persons to these offices. If the governor did not furnish sufficient particulars, The county assembly had the option of rejecting those names. Just consider them and reject them, so that there is no jam in the system, so to speak. What has happened here is that for more than 1 year, the county assembly has engaged the governor's office in correspondence, but failed to make a decision on the chairpersons of these boards. And yet there is nothing the governor can do without the county assembly first making a decision one way or the other. The law, for example, distinguished senators, requires that ambassadors in this country, cabinet secretaries, be appointed by the president, but upon approval by the National Assembly. If the president were to forward names of cabinet secretaries to the National Assembly, then the National Assembly takes 1 year engaging the president in correspondence on those names without making a decision on them. Then eventually moves a motion to impeach the president for failure to appoint. That is malice in the extreme. I have reflected on the various categories of malice. I submit respectfully, this will fall into the category of malice of the highest order. This is a teaching aid in malice. It is inconceivable that there can be a higher grade of malice than this. You have been told that the governor has failed to implement the recommendations / resolutions of the county assembly. You are taken through the letter by the clerk claiming to be forwarding a resolution of the county assembly. In fact, that letter, when you look at it, it says that the Hansard is also enclosed. We have asked for that Hansard. We have asked for that resolution. Distinguished senators, it has not been presented to you. The question is, how will you impeach the governor on the strength of such an allegation? But more importantly for me, questions were put here to a number of witnesses to show who that report of the assembly, of the committee of the assembly is addressed to. That report was addressed to the petitioners, not the governor. Who was that report copied to? That report was copied to the various officers who allegedly the petitioners had sought to be removed from office, one by one. That report was neither addressed to nor copied to the governor. But now you are told to make a finding that the governor failed to implement that report that was neither addressed to her nor copied to her. As a matter of fact, can we say that in accordance with the law, the County Assembly of Meru has established this fact? I repeat, it is not in my place to make that determination. It is in your place, distinguished senators, to make that determination. I invite you to make that determination with this factual matrix in your mind, so that you vote that in good conscience, a governor who is neither the addressee of a letter nor copied in the letter can be removed from office on an allegation of failure to implement the contents of that letter. Factual matters on the dismissal of Dr. Ntoiti, Paul Mwaki, Kenneth Kimathi Mbae, and Joseph Kathure Mberia have arisen in addition to the principal matters of pendency of court cases in them. Factual matters have arisen. To the factual question whether these people have been dismissed from office, the county executive CAC in charge of public service has been here and has adduced evidence that these people, some of them, their contracts ran out by a fluxion of time. That a contract that has ended. Number two, you are told the governor never dismissed these people. good people, distinguished senators, would it have been easier than for the county assembly to present us with at least a sample dismissal letter of any of these people? The multiple volumes before you contain very many documents except anything in the name of a dismissal letter, even to prove that fact of an allegation of dismissal. You are going to make a decision this evening. I want you in good conscience to reflect on whether you can dismiss a governor for alleged dismissal of an employee without the dismissal letter before you, without an affidavit of that employee before you claiming to have been dismissed, and yet you are told, remove this governor from office. Correct. An allegation has been made that this governor deliberately and knowingly misled the public that 86 million shillings had been raised through pay bill number 247247, account number 04001639178999. First, let me contextualize that video. We had the opportunity to review that video, distinguished senators, and you are aware that other videos have been played to show just the amount of mud that was thrown at the senator, so at the governor, not by the family of the deceased, not by the wife of the deceased, but by persons, whether called activists or other leaders from Meru County. You listen to that clip and you have no doubt in your mind the governor is addressing those leaders who are throwing mud at her. I think that when I finally document the story of this governor, as I hope one day I'll get to do, she's the only leader who has been expected to have mud thrown at her with no corresponding right to respond. Because every time she responds, those very scurrilous attacks, she is brought here for impeachment. All of us had somebody claiming that a body of a deceased person would be placed in the home of the governor and to remain there, and if push comes to be brought to this Senate. How do we expect a fellow citizen not to respond? Human beings have an instinct of anger, have an instinct of shame, have an instinct of pride that is natural, normal human instinct. There's nothing inherently wrong in those human values. It's just the way God made us as human beings. And when the governor responds to those leaders, clearly saying those leaders must then support the deceased wife, build a house for her, buy her a car, start a foundation to support her children. I think, judged in context, that is a governor who is empathetic to this widow and who is calling for her to be assisted rather than being taken advantage of for political ends or possibly for business ends. I would want this particular charge to be understood in that context, distinguished senators. Ground number 3, at paragraph 8, an allegation is made of an alleged use of manual payroll. First, I think sufficient evidence has been laid here that this was an issue in the audit report. The county assembly is yet to consider that audit report and recommend appropriate action or seek answers from the county executive. Evidence has been laid to you that this governor inherited a government where manual payrolls were a systemic problem. In fact, she has finished that problem before this impeachment motion was filed. That is something I beseech you to keep at the back of your mind as you make a decision one way or the other on these proceedings. Evidence has been laid before you that the issue of manual register has appeared in audit reports in respect of an excess of more than 40 counties. What lesson do we learn from that? This may be a systemic government problem beyond Meru County, and therefore the proper interventions by legislative and oversight institutions such as this is to provide systemic solutions. What can we do to ensure that IPPD numbers of staff are processed much faster to conduce an environment where payrolls are run without the necessity to resort to manual payrolls as we wait for IPPD numbers? You will empathize with the governor that if her government were to keep kindergarten teachers without salary for 8 months pending processing of IPPD numbers by another government institution, that may as well be an unfair labor practice, which will also violate the Constitution. I have addressed the question of employing a bloated workforce. As a matter of fact, the governor has not employed a bloated workforce. As a matter of fact, this matter has been dealt before in a previous impeachment motion. As a matter of fact, evidence has been laid here of the governor's office rejecting other staff being sent to her office. I beseech you to keep that fact at the back of your mind as you make this decision. Finally, on the allegation of paying Kiambi Christus Manyara, a public communications officer in the office of governor, full salary while in remand, distinguished senators, I want you in good conscience to make a decision whether governors pay staff. Just in the government organogram, whether a governor pays staff. The appointment letter of this particular staff shows that this is actually a staff of the County Public Service Board. That's the appointing authority, that's the disciplining authority. So that where a staff who is charged in court is supposed to be either suspended or interdicted and relevant communication made to the payroll team, that would be the function of the County Public Service Board, which is an independent board established as such under the County Government Act. To blame the governor for the failure or omission of an independent board, which if the governor sought to interfere with, that may as well be a ground of impeaching her, that will be putting this governor in a grave dilemma. We beseech you not to put this governor or any other governor in such a position of dilemma. The Supreme Court of Kenya, in the case of Sonko versus the County Assembly of Nairobi, set a principle, and I quote, though a political process, impeachment is sanctioned by the Constitution and the law, and it is not a platform to settle political scores. It is well within the rights of the governor to adduce evidence before you to show what political machinations are there, so that you can contextualize her allegations that these are processes to settle political scores. Make no mistake, distinguished senators, the governor has set out here. She is a leader like any other leader. She is subject to oversight like any other leader. She is subject to sanction like any other leader. But let it be fair oversight. Let it be fair sanction. Let it not be politically motivated sanction. A side issue has been raised here that this governor is waving a gender card. When the governor was brought here in September last year, she told you, this house, that she was a victim of misogyny. She didn't stop here. She played video clips here for you to see with your own senses, for you to hear with your own senses, for you to feel with your own senses. The decision was yours, and the answer of this house shows that even this senator was abhorred by the misogyny that was displayed in those videos. The governor is not creating a narrative of misogyny. The governor presented evidence of misogyny before this house. A narrative has been created here that this governor has been given 2 opportunities before. An impression being created that this governor was perhaps convicted and pardoned. truth is, this governor has been acquitted on every other occasion that she has been brought here. And therefore, you can't blame her for whatever decision this Senate made based on the evidence that has been brought before the Senate. The case of Martin Nyaga Wambora before the Court of Appeal of Kenya set out the principle that allegations for removal of a governor must be serious, substantial, and weighty. Let's face it, if we want to look for technical infractions of law, that is easy. We can get a technical infraction of law on any officer in any office, on any citizen, wherever situated. The principle as enunciated by our court is that to remove a governor from office, the allegation must be serious, substantial, and weighty. And it's in this context that I understood the clarification sought. 5 minutes, thank you. The clarification as sought by Honorable Senator Kajwang as to whether labor disputes, employment disputes would form a basis of an impeachment motion. This institution of parliament has employees. I leave it to your own assessment as whether there are any employees that have ever taken this institution to court. What is sure is that there's an entire court called the Employment and Labor Relations Court, whose business is to resolve labor disputes every day. We don't create institutions for fun. That institution was created because there was an understanding that in our day-to-day lives, people are going to have labor disputes. And therefore, to use a labor dispute that is properly before a court of competent jurisdiction to remove a governor from office, that in and of itself does not pass the test of seriousness, substantiality, and weight. The Court of Appeal also established as a principle that a nexus must be drawn between the governor and the alleged gross violations of the Constitution or any law. So that where the County Public Service Board, for example, fails to interdict or suspend an employee who is charged in a court of law, it strains my imagination how anyone within the most fertile imagination on earth can create a nexus between that and the governor. I leave it to the distinguished house here to make a decision on that question. In conclusion, distinguished senators, I have been reflecting on the life and the times of Honorable Kawira Mwangaza. In my other world, Mr. Speaker, I am a teacher, and I talk to my law students every day in a mentorship program, and I was telling them that in the fullness of time, when I am tasked to make my intellectual contributions on gender and the law, my writing will not be on the 2/3 gender principle. My writing will be on the struggle to sustain a woman governor in Meru County. It is difficult for me to imagine of any public official in this country who has been subjected to the trials and tribulations of this governor. This governor who stands here, I look at her and see either my elder sister or my mother. I can't imagine of a lesson in resilience than that is embodied in this woman who sits here before you as governor. I beseech you to have the weight of this submission in your conscience as you grapple with the principal issues, the evidentiary issues, and the factual issues that I have raised this evening. I beseech you to acquit this governor on each of the 3 counts. I rest the governor's final submissions.
Thank you, Counsel. Now, honorable senators, ladies and gentlemen, we will now, pursuant to Rules 27 of the Rules of Procedure as contained in the 3rd schedule of our standing orders, we will proceed to a camera session. And therefore, at this juncture, I'll ask the parties to withdraw from the chamber, the members of the public to withdraw from the chamber, and the media to cease live broadcast forthwith.
Ijiri Baite TV, Baite FM, 90% Udongo kwetu.
Kesha kanisa ya Baite Family Fellowship itongeretwe ni Bishop Kawira Mwangaza nibo kugwata kiri kesha ya mwanya ya gwitorora kumuthathaiya na kumwambararia Mwathani Murungu wa theru tuko ya Jumaa tariki 23 cia mweri jojo wa 8 iria mbere ya 3 cia ugoro ikarika runene rukiri ririkana kesha iji ikethera igwatitheni kundi kagumba bianto baria bachiritirite ni kenda bakathathaiya